Good evening, everyone, and welcome to this webinar organized by the School of International Arbitration here at Queen Mary University of London. My name is Dr. Remy Gerbay, and I'm one of the academics here at the School of International Arbitration. I'm also an arbitration partner at US law firm Hughes Hubbard Reed in Washington, D.C. Each year, the School of International Arbitration organizes about half a dozen webinars like this one, where we invite friends and supporters of the school to come and discuss topical issues in the field of international arbitration. As you may know already, the purpose of this series of webinars is really twofold. First, we want to give our students at Queen Mary University an opportunity to hear different perspectives, often more practice-oriented ones, on the issues that our students study in the course of their LLM at Queen Mary. And second, we want to continue to build and nurture this relationship, the uniquely deep relationship that the School of International Arbitration has with the international arbitration community. And we do that by offering a free and open forum like this one, where practitioners, students, and alums can come and jointly continue to learn together about international arbitration. The topic of today's webinar is Guerilla Tactics in International Arbitration, when arbitration becomes a not-so-civil war. And to help us navigate this really interesting topic, we have the pleasure of having two brilliant speakers today in Saadia, Bhatty, and Alexis Martinez. Now, Saadia and Alexis bring together decades of experience in international arbitration at the highest level. Saadia, as you may know, is an attorney admitted to practice both at the New York and Paris bars. She practices in the International Dispute Resolution Group of Gide, Loyrette, Nouel, a French international law firm, here in the London office. She advises and represents both states and private entities in a wide range of contentious but also non-contentious issues relating to international commercial investment arbitration, as well as public international law. She's a graduate of Harvard Law School, Sorbonne University, and last but not least, the prestigious École Normale Supérieure, or ENS, in Paris. Saadia is also a member of numerous boards and executive committees, including, for example, the Federation of Investment Law and Arbitration, EFILA, friend of the school, the Africa International Legal Awareness, the Pakistan Center for Law and Society, Arbitral Women, and also the Harvard Women in Defense Diplomacy and Development. So at this stage, you're probably thinking, wow, this Saadia Bhatty is incredibly qualified and accomplished. I hope for his own sake that our second speaker, Alexis Martinez, is equally accomplished. And the good news is that Alexis Martinez is indeed equally accomplished. Alexis is a partner in the arbitration group of Squire, Patton, Boggs, US firm here in London, where he routinely represents states and multinational companies in international arbitration, both investment and commercial. He also regularly sits as arbitrator. And Alexis does that in 3 languages, English, Spanish, and French. And he has acted for numerous parties in Latin America, Africa, Asia, the Caribbean, and reading from his bio, all of these cases resulted in favorable multi-million-dollar awards or settlements. So for the past decade, obviously he's been playing his trade with Squire, Patton, Boggs, but before that he practiced arbitration with Allen Overy and Baker McKenzie in London, Bumchill in Argentina, and he was also a research assistant to the much regretted Martin Hunter at Essex Court Chambers. Martin Hunter, who was a big supporter of the School of Arbitration and often taught at the school when it was first created by Julian Lowe. So needless to say, Saadia and Alexis are featuring prominently in all of the legal directories where they're recommended by their peers and clients as exceptional lawyers. So all of this to say that we're very lucky to have both Saadia and Alexis to talk to us about our topic tonight. Saadia, Alexis, good evening and welcome. Now, as you know, Saadia and Alexis, the format of the evening is a roundtable, which means that I'm going to take you through a number of questions. And the purpose essentially of my questions will be to tap on your knowledge and experience of international arbitration, to try to better understand what we mean by guerrilla tactics, and to also perhaps better understand what counsel and arbitrators can do to respond to and handle these guerrilla tactics as and when they arise. And so if that's okay with you, I think a good starting point would be to try to understand the notion of guerrilla tactics, which may not necessarily be actually familiar to everybody. And you might have read about it, but you may not have thought about exactly what it means. So would you be able to very briefly, by way of introduction, tell us what we mean by guerrilla tactics? Maybe Saadia, if you want to start.
Yeah, I mean, I can start. First of all, thank you very much, Remy, for this very, very kind introduction, and of course for this warm welcome to this event and the invitation. And I'm very happy to be here and sharing thoughts here with Alexis and you. So guerrilla tactics. Maybe I can start just with the term in itself, guerrilla. I mean, it literally means little war in Spanish, and guerrilla warfare. And it has to come to mean a form of irregular warfare and refers to conflicts in which a small group of combatants, including but not limited to armed civilians, or regular use tactics such as ambush, raids, and the elements of surprise to harass the traditional army. Okay, so that's the literal definition. Now, in our context, it's been defined as when parties who will try to exploit procedural rules for their own advantage, to delay the hearing if they get an opportunity, for example, and ultimately to derail the arbitration so that it becomes abortive or ineffective. So that was a definition that was proposed by Michael Wong, which I think is good. So I would say delay or just derail the arbitration in our field. That is a short definition that I would take.
And Alexis, I don't know if you have anything to add on the definition point, or perhaps some very brief examples. We're going to have an opportunity to dissect some of these, in later on this webinar. But I don't know if you have a couple of examples or anything to add on the definition.
Thank you, Remy, and I wanted to thank you also for your very, very kind introduction. I almost felt like eulogy. I'm glad I'm still around, but that way I know if I pass away, I know what people will say. So thank you so much for being so kind and generous. I largely agree with what Saadia is saying. I thought actually it's a really interesting question. What is guerrilla tactics in arbitration? And I think for me, it's a way to try and get an advantage consciously. It's not a mistake, it's deliberate, to consciously get an advantage for your client by using the process of arbitration in a way it's not intended to be used. So you're actually using the process, but not the way it was intended, to get an advantage, and you're aware of it. And having laid down this very broad, but I think accurate definition, I think we can see there's really three types of guerrilla tactics. They are the ones that everyone agrees on, which you're subverting arbitration. I think that's what Saadia was mentioning. Then there are the ones that are more extreme, and this is borderline criminal behavior. This may happen. This is tapping the phone of a witness. This is witness intimidation. This is kidnapping an arbitrator. Some people might say this goes beyond guerrilla. This is clearly illegal tactics. And then there's also being an aggressive advocate, which some people would say is fine. And that would include, for example, not putting forward evidence that goes against the interests of your client, waiting till the very second of a deadline before submitting an issue, being quite aggressive with the other side. So I think it's really important to be aware that there's a whole range of guerrilla tactics that can be used. Some are deemed acceptable nowadays in arbitration, like being aggressive. Some are deemed, frankly, criminal. And some are somewhere in between. They're frowned upon. They're very arguably unethical. And I think these are the ones we'll be dealing here mainly today. And as we go on as well, I've got so many examples of tactics. I was in a hearing actually literally just yesterday facing guerrilla tactics. So I look forward to being able to give you so many examples. I think you're on mute, Remy.
Sorry. I was going to say we have a lot of attendees. It's a very successful webinar, so maybe some of your opposing counsel will be listening to to you today. I'm joking, Alexis.
I hope they are, but don't worry, we'll all be anonymous.
All right. So thanks a lot, Alexis. And to so to pick up on your distinctions between three different types of tactics, depending on I guess the level of acceptability. If we leave aside, I guess the extreme behavior which constitutes criminal behavior, how exactly do we draw the line? I mean, if we try to scratch under the surface, and the reason why I'm asking the question is the following. We know that international arbitration is a multicultural practice area. We have counsel, parties, and in fact, even arbitrators coming from different jurisdictions who thus necessarily are going to have a different understanding of ethics, but also a different approach to advocacy to start with. And so differences in terms of what is acceptable and what is not, what is robust, aggressive advocacy, but zealous advocacy, but is not guerrilla tactics, might vary from jurisdiction to jurisdiction. So if in that context of international arbitration, how do we draw the line between what's acceptable and what's not? Can we even do that, or is that a quest that is impossible?
You want to go first, Saadia?
Sure, I'm happy to go first. I mean, I might answer the question with an answer myself. First of all, I completely agree with the assumption that you have made, which is to start with by saying that we all come from different practices as arbitration practitioners. I think this is the definition of the practice in itself. It's international. So not only are counsel from different, jurisdictions, but you're dealing with different parties that come from all over the world. And we're also dealing with different arbitrators from different nationality. And oftentimes they sit next to each other in the same panel. And that's important, I think. So I think your point in saying, well, I mean, can we define, what is acceptable or not is actually very difficult in the practice, because what is considered, and like you said, of course, we gave examples, extreme examples that Alexis gave, and which happen often, in fact, unfortunately, the very extreme examples, which were the kidnapping of witnesses and intimidation of arbitrators and so on and so forth. I think we can all agree that that's frowned upon and that is not acceptable. In other terms, illegal. I can even go so far as saying criminal. But there are other practices, because we mentioned delaying, obstructing the proceedings. And I think we're going to go in more detail in what we're talking about here. Just for example, and I think this is pretty timely to talk about virtual hearings. Can you say that opposing to a virtual hearing is in itself a guerrilla tactic? I mean, it's very difficult to argue that it would be, but again, it depends on the circumstances. Maybe it is. Maybe it is. It's just they're using it as an excuse to not to block the advancement of the proceedings. So I'm sorry to say, I will agree and say I think it's in the views, it's very cultural specific in the eyes of arbitrators and practitioners and your own bar standards, ethical standards, what is acceptable or not. And B, I would say it's also very fact specific to the case, because an accepted behavior might not be acceptable if you understand the circumstances of the case and if it's a repeat behavior, for example.
That's interesting, Saadia. Alexis?
Yeah, I completely agree with Saadia, with what Saadia is saying when she says that, and what you said actually, a diagnosis that depending on who the counsels are, who the parties are, who the arbitrators are, people have different feelings about what amounts to guerrilla, what doesn't. However, in my way, it's kind of similar with the way, how do you want to conduct your arbitration? It's kind of a similar question. And in my mind, the answer is kind of built into the whole process of arbitration, which is the parties appoint arbitrators that they want. And in appointing the arbitrators, in selecting the arbitrator, they arrive at a panel that will reflect their own views on what constitutes guerrilla tactic and a proper arbitration. So there are so many ways to conduct an arbitration or a guerrilla tactic, but what we find is based on the parties, based on the arbitrators, They tend to be consensus that is reached. So in my mind, it's a question that's actually resolved by itself. When you appoint the tribunal, you appoint a tribunal you're happy with, that should reflect your values. And in doing so, you select a tribunal that will apply a reflection of guerrilla tactics that reflects your own values.
So presumably, Alexis, you're saying you would appoint, for example, somebody who you know is going to have no patience for guerrilla tactics, right? Or the way you understand them and was going to run the case, you would want them to run the case. I guess that's the idea from a practical standpoint.
That's an example. If you want a case where that will be run efficiently and on time, you will appoint someone who is known for insisting on deadlines. If you want someone who's very commercial, you will, and someone will be able to give you more leeway, perhaps, then you might appoint someone that goes more that way. I think we should not forget that arbitration is in the hands of the parties, literally, because they're the ones who define the rules. It's a creature of contract, and then select the adjudicators who will apply those rules.
It's very interesting. So, and it completely blows out of the water my next question, because I think we're landing right now on the understanding with Saadia and Alexis that it's very difficult, if not impossible, to define these guerrilla tactics because they're very culture specific, and so the way a particular conduct is going to be perceived either as guerrilla tactic or acceptable behavior is going to depend on the person, the arbitrator at stake, and so parties should choose carefully the arbitrators, etc., etc. So there is no, I guess, common understanding of guerrilla tactics, but I'm going to play a devil's advocate nonetheless. Don't read anything into my question as to what my opinions might be about guerrilla tactics. I'm really just asking a provocative question here. But what about cultural relativism? So if we agree that we have to be cognizant of the fact that in international arbitration, we have practitioners, participants from different cultures, isn't there a danger that by labeling a certain conduct as guerrilla tactic, we in fact seek to impose our way, presumably Western European or North American way of conducting arbitrations? So we know that international arbitration has evolved a lot over the past 25 years. There's been a regionalization of arbitration with new entrants, new counsel, parties, arbitrators, even arbitral institutions being active in arbitration. And so at the end of the day, isn't the debate about guerrilla tactics just some old European practitioners moaning about their loss of control of how arbitration is conducted and should be conducted? I mean, it reminds me a bit of the Americanization of arbitration, where European practitioners were bemoaning the aggressive and approach of Americans in litigating claims before arbitral tribunals. So is there any truth in that, or not?
I think I agree with you, Remy, when you say that my answer kind of preempted yours. So, you know, the parties choose the contract, they choose the rules, they choose the arbitrators. In a way, they choose their own definition of guerrilla tactics. But I'm not sure I agree with you when you say that it's, you know, the old guard that's suddenly being shocked at the behavior, because as far as I can see, unless a behavior crosses into the criminal, there's barely any sanction attached to guerrilla tactics as I see them happen in arbitration. So I would not say that it's people grumbling. I would say that actually there's possibly a need for people to not just grumble, but take action, and that's starting to happen. You mentioned, you know, there's the LCIA rules, they have an annex with ethical rules. There are the Hague Standards for Ethical Counsel and the ALL working group, which I helped draft. There's the IBA guidelines for counsel, which are also helpful. So, I mean, so my point is, I'm not sure that it's people grumbling. I think it's something we've observed that needs to change and be addressed.
So there is some level of objective reality about this notion of guerrilla tactics. That there is a core of conduct that is just that everybody would agree needs to be wiped out, basically. Saadia?
Yeah, I was about to say, Saadia, I may have a view on your first question.
So I think this is a very, very interesting question. and of course, in complement to everything, I think Alexis made good points on the guidelines and the code of conduct that exist on regulating behavior. But more on your pointer, are we not going to impose a Western standard? I think that we had that discussion also with maybe on the guidelines on taking of evidence. What is constituted, normal in the taking of evidence in arbitration? What is not? Is that an Americanization of the process? And I think your question is, are we not going to impose like Western standards of what is acceptable in, for example, the French bar versus what is acceptable in the Nigerian bar? Or I don't know, the American versus the European might be the big divide on what is acceptable and not acceptable. I think that's a fair approach to say that we might, be imposing standards, but I also, and this is based on my experience, I think there's a common understanding of what is okay and what is not okay in the sense of what is decent and not decent. There are some things that should not be acceptable, and arbitrators see it, whether they're Western qualified or whether they're not qualified in this part of the world, whether they're common law lawyers, whether they're civil lawyers. And on the point of Alexis saying there's hardly any sections, in fact, I would respectfully disagree on that. When you look at cost sanctions, cost awards of arbitrators, they do take into account the behavior of the party and counsel in particular. And how that has been approached. And
it's a great point, Saadia, actually, and such a great point that we're going to, I think, look at it again more specifically towards the end of this roundtable. I'm looking at the questions we've got in the chat function. By the way, feel free to ask your questions. We'll try to address them if we can. And I think now would be a good time to become a bit more granular about what we talk about when we talk of guerrilla tactics. And so I think one way to do that would be perhaps to look at what guerrilla tactics are from the point of view of counsel, and giving some examples of what these guerrilla tactics can be, what you've seen in your practices, Saadia and Alexis, starting maybe at the beginning of the proceedings when the arbitration is about to start or has just been started. So typically it starts with a request for arbitration, or if it's an institutional arbitration, or a notice of arbitration if it's a ad hoc arbitration. So any examples of things that you would label as guerrilla tactics at that early stage of the process?
Alexis, do you want to go first? Because I know you just came out fresh from a hearing. So maybe do you want to go with your examples, and I'll complete them.
Thank you, Saadia. So I'm going to give you examples which are entirely anonymous and have, of course, nothing to do with may have nothing to do with existing people, states, countries, councils, representatives, or companies. But one of the, well, I've got a whole series right at the start, but one of the biggest one is pretending that you have not been notified. So, for example, saying that either, well, more likely claiming that the person who was notified was not the right person to notify, even though it's clearly wrong. I've seen that. Nowadays, you tend to send files using download links because they're too large to be sent by emails, claiming you're unable to download the files. In addition, in fact, putting a 5 megabyte, say, limit on your email means it's very hard for you to receive PDF documents and therefore arbitration documents. That's a great way to avoid having notification. Claiming the person who got the notice was not in the office. All of that I've seen and is common at the start.
And Alexis, so just suppose for a second, so these are great examples, but just to really spell it out for those of the attendees who may not necessarily understand why notification is important, what the consequences could be for the rest of the process in case of the defective notification. Why do you think that there's so many guerrilla tactics around notification of the proceedings? Very briefly.
Because notification will start most of the deadlines. It's true that actually in practice, if you look at it, notification, if you look at it in detail, is actually not that important. And at some point, the arbitration can proceed ahead regardless, because the other side will be deemed to have participated. However, that then raises questions as to enforcement later on, because the other side can say, I was not given a chance to participate in the proceedings, I was not properly notified, therefore you cannot enforce your award against me. And that means that by having tainted right at the start the whole proceedings, there's this shadow over the entire arbitration where one party is wondering whether it's worth it at all to go through the arbitration. And in doing that, you've created an imbalance in the proceedings. You got one party is constantly worried about whether or not the award will stand, and the other one that has nothing to worry about.
That's great. And I'm sorry, I cut you mid-sentence before, so I don't know if you had any other examples of guerrilla tactics at the beginning, or if you were done with your...
I mean, a lot of them have happened right at the beginning. I mean, one that's very common is there are various procedures under the exit rules, the ICC rules, to say, actually, there's no arbitration agreement. Therefore, you should reject straight away the request for arbitration. And of course, there is when there's an arbitration agreement. But nonetheless, they make the objection, because then usually the objection has to go in front of the Secretary General or the President of the court, etc. So it adds a few days, sometimes a few weeks before the arbitration can go ahead. They can go with they can delay things. Mm-hmm. The other one I've also seen more than once, which again delays things, is they appoint an arbitrator that is clearly biased. I mean, even though you need an urgent remedy, you're forced to object to the nomination of the arbitrator, which takes weeks, and then wait for another nomination, which adds further weeks, because they have appointed someone that is clearly entirely biased. And the example I have in mind is the other side appointed one of their own external counsels. So you could not have been more biased.
Saadia,
do you have anything to add to this?
Yeah, so I mean, again, but the examples given by Alexis, I've lived them firsthand experience. So I can only reiterate that failing to acknowledge receipt is one that happens often, for sure. Before even going to the challenge of the arbitration clause, I can give you some more specific practical examples of what I've faced with, specifically also in investor-state arbitration, which happens because of maybe the fact that they're states, so they might have different approaches. Query as to whether you might qualify this as a guerrilla tactic. Okay, so caveat on that. But I've seen cases where it inevitably delays the proceedings when the state would say, wait, I need time to instruct counsel for this. Yes, I've received the request, okay, but I need time to instruct counsel. I don't have appropriate counsel, and it can take a very long time. Okay, so unless they've got counsel, the arbitrator will not set up, a procedural hearing, and so it won't start the process. There's also another one which I've seen is where you have they haven't even made the agreement as to which proper minister will be giving the instructions on behalf of the state. So even if you in the request for arbitration say the claimant has sued Ministry of Justice and the Ministry of Economy, the Ministry of Justice and the Ministry of Economy might not have a coordinated approach. Typically what Alexis just mentioned, appointing an arbitrator, okay? And that might take a long time. And that's internal dysfunction, which you can deal with. Your hands are tied because you have to deal with them figuring it out. And the risk of an arbitrator saying, hey, you need to figure this out within a week or right now, is then the state complaining that it was violated its due process, it wasn't given adequate time to keep its affair in order internally, and not have been able to prepare a defense in a reasonable time. Which means, to go back to your point, what impact it has legally is if you argue that your due process rights have been violated during the arbitral process, then of course it's a sign that this, that you might challenge the award going forward at the end. So the arbitrators are super cautious on this. Every time a party says, well, if you do this, it's going to violate my due process rights, then they're like, oh gosh, I want to make sure this award is totally, forgive me the expression, but kosher or halal or whatever you want to say, and make sure that there's no annulment proceeding at the end. So I'm going to give time to the parties to organize themselves. So that's a little example that I wanted to give.
So that last point is really great. It works well with one of the questions. We're getting fantastic questions, by the way, in the chat from different people, and Brian and Todd Weiler and others. I think some of them we're going to keep for the end of the conversation because they're going to open, a completely different line of discussions, but we're definitely going to address them. They're really good. But one of the questions in the chat was specifically about the overlap, I guess, between the notion of guerrilla tactics and due process paranoia, which I think, Saadia, is pretty much what you were putting your finger on. Do you have anything to add, or do you want to expand on that? Or maybe Alexis, if Saadia, if you want to pass.
Sorry, I'm just trying to get hold of the question. Sorry,
so the question is simply, can you talk about the connection between due process paranoia and guerrilla tactics, I guess?
Yeah, so I think maybe Alexis, if you wanted to comment on the point that I made, and then I can.
Yeah, no, happy to. I think it's a very good point, because there is this fear in tribunals, this very real fear, and I understand it, because whenever I sit as arbitrator, I have the same fear. Will my award be executed? If not, will it be set aside? And one of the easiest ways to set aside an award is one party has not been granted full due process. So you want to be extra sure that that everyone is granted an opportunity to make their case. In fact, particularly if they are likely to lose. So, there's this pressure on arbitrators to give as much time as needed for the other side to appoint counsel, to do what they say they need to do to put their case forward. And I found in practice that arbitrators will tend to give credence to whatever is invoked to justify the guerrilla tactic, unless they have evidence that it's false, and often it's quite hard to prove that something does not exist or is untrue. Unless it's evidence that it's false, they will tend to act as if they believe them, and therefore that means more time. And again, if there is a request for time extension, I found tribunals quite willing to give them. Even I have an example in mind where, by asking for a 2-week extension, because we had such a prestigious tribunal who was so busy, the 1-week extension for a hearing resulted in the hearing being postponed by 18 months, because there was the next time all 3 arbitrators on the panel had 2 weeks in a row available. But nonetheless, they granted the extension. And these are 3 of the top arbitrators, but they had no hesitation in doing it. So in my mind, the fact that we have 3 top leading arbitrators illustrates just how pervasive the conflict in due process and guerrilla tactics is, which is why it's important, I think, that we extend the tools that are available for arbitrators to deal with it.
Thanks, Alexis. So we're getting a lot of really good examples through your answers. I mean, some of them relate to later stages of the proceedings. So there's another one that I've seen at the beginning of proceedings. I thought it was very interesting, and definitely a guerrilla tactic in my book, definitely something that's not acceptable. But in some jurisdictions where enforcement of an arbitral award is difficult, despite the fact that that jurisdiction might be a signatory of the New York Convention, some losing parties in arbitrations are going to argue that while lawyers participated on their behalf in the arbitration, in fact, these lawyers were not properly instructed because there was no power of attorney or something like that, such that really they did not get a proper chance to fully defend the case, which sounds like a terrible argument to make in if your frame of reference is London or Paris, Geneva, or New York. But in some jurisdictions, at least historically, it used to work. And so I remember a case where a party was asked by an arbitral tribunal to provide a power of attorney to show that they had been validly instructed to represent the interests of that respondent throughout the arbitration. And at first, the counsel refused or just ignored the request. And then when prompted multiple times, they provided a POA, which had a date in very small characters at the bottom, and which was not going to be, the duration of which was not going to be long enough to cover the entire arbitration, and certainly not the hearing. So I thought that was really cheeky, to put it mildly or politely, but hopefully this is not something that you have seen yourselves in your respective practices, Saadia or Alexis, or at least
No,
not
I've seen
too
it.
often.
I've seen it, Remy. I've seen that exact same thing happen to me as well. You know, contesting the power of attorney and so on. And it's the whole separate, you know, parallel proceeding as well that starts, you know, on this. And I also wanted to make the point on another one that happens often, and which again, you know, it depends, you know, whose view is whether or not it's a guerrilla tactic. But say your client says, well, you know, contest the arbitration altogether. Having given consent to arbitration will challenge jurisdiction, of course. But your client says, I'm not going to pay a penny for this. I'm not going to pay. I'm not going to advance my share of the advance of costs for that arbitration. You know, I mean, in multiple institutions, and you know, taking the example of an exit case, if the state says I'm not going to pay my share of the advance of costs, which is a lot of money. Okay, the first share, I think it's around 150,000 or something. I mean, it depends on arbitrations, but you know, they're not going to put in the money. What's the consequence? Because I know a lot of people are asking what the sanctions are. Well, if the claimant doesn't pay for the advance of the share of costs of arbitration, which is supposed to be paid by respondent upfront, they're not going to pay that extra 150,000. The arbitration is not going to proceed. Okay, so that has a direct impact on the arbitration right there. So if that's not a guerrilla tactic, if the jurisdictional objection is unfounded, then what is it?
And it seems to, it's a great question. It's one that, in fact, had been raised by Tatiana Minaiva in the chat. So thank you for raising it. And I think it's even more unfair if, in the context of investment treaty arbitration, if the reason why the claimant is unable to pay the respondent's share of the deposit is precisely because its business has been destroyed, allegedly, by the respondent. So that's a very interesting one. So maybe one answer to that is immediate cost awards. I know that in some instances, but I get the sense it's pretty rare, an arbitrator would, if dismissing a claim for failure by a claimant to make a substitute payment for the respondent's share of the deposit, they could make a what they could do is say, okay, if you pay your share as claimant, if you pay the respondent's share, I will make an immediate cost award so the claimant can recover at least that, and that sort of incentivizes a little bit the respondent, but of course it's for claimant to ask the arbitrator.
That's something I've had, the non-payment is something I've faced very often. It's incredibly common, actually, much more than you'd expect. And I think what I found works is that by not paying their share of the advancement costs that they've agreed to pay by signing up to the arbitration clause, they are in immediate breach of contract. So you can actually get a decision that would say they are in breach of contract and then enforce it as separately as a separate breach of contract claim for the amount of whatever is left to pay. So for that one, thankfully, there is some sort of remedy. You can say you're in breach of contract, breach the arbitration provision, it's immediate, you need to pay up now.
That's a very interesting one, yes. Whether you can action under domestic law of the law of the seat of the arbitration, I guess, action a breach of the arbitration agreement and seek remedy payment of money for the damages caused by the breach of the arbitration agreement. Yeah. I've never seen that done, but I know it's often discussed, and I'd love to see if you have a case, and if you're, anybody here is aware of a case, I'd love to read it. All right, so we focus a bit on primarily on the first stages of the arbitration, the commencement of the arbitration. I think next step is the constitution of the arbitral tribunal, and here, of course, sometimes parties are going to be tempted to appoint as one of the three arbitrators an individual who they think is going to be biased, somebody who is going to lack the independence and or impartiality that is required of their role. And again, culturally, I think it's important to remember that in certain forms of domestic arbitrations, having a biased partial arbitrator for each side is actually part of the process. I'm thinking, or almost part of the process. I'm thinking of employment arbitration or some forms of domestic arbitrations where you have non-neutral arbitrators, sometimes in the United States, for example. So, but here we're talking about international arbitration where all arbitrators, regardless of whether they've been appointed by a party, should be independent and impartial. So to what extent, trying to appoint somebody who you think is going to have a predisposition towards your case, which we all do, to what extent that when do you cross the line of guerrilla tactic here? What's acceptable and what's not?
I think Alexis gave a really good example early on. Is what is not acceptable is having an arbitrator who was, what did you say, Alexis, was a counsel for the other side?
Yes.
Point? I mean, that in itself is not acceptable. Having an arbitrator that has certain views on your case, some views on, and again, sorry for giving another example, investment arbitration, but there's this whole challenges that exist on issue conflicts, potential issue conflicts, and where you've determined a question that is very similar, that is the question put to the arbitrator in this proceedings. It's very debated whether or not that's a guerrilla tactic, because honestly, yes, I agree, Remy. When you choose your arbitrators, don't we all look for all their papers and their profile? The fact that we want to choose an arbitrator, of course, an arbitrator is supposed to be neutral, but you want to have an arbitrator that's going to be, that has some views that would favor your case preferably, and that's what every single counsel is looking for, is to looking someone who looks for your views on the specific matter. It's difficult to tell, right? But has a certain views on questions that have been put forward to it. That I think is completely legitimate.
So I'm going to ask you. I'm going to put a scenario to you and ask your views, and maybe people in the audience can respond as well using the chat function. But without telling you more about the case, what do you think of the situation where, let's say, a respondent and their outside counsel collectively have appointed an arbitrator 9 times, but the most recent appointment is more than 3 years ago, such that if you look at the IBA guidelines on a conflict of interest and the traffic light system, it's not clear that there is a conflict for the purposes of the guidelines, at least. But at the same time, 9 times is not nothing. You would assume that this person would have derived a non-insignificant portion of their remuneration over those 9 years from collectively the party and their outside counsel. So is that a guerrilla tactic, or is that completely fine on the basis that it's not 3 appointments in the past 3 years? So is it okay or not okay? If you want to put your answer in the chat. And Saadia and Alexis, I don't know, is that a guerrilla tactic or is that not?
I'm going to sidestep, if you don't mind if I go. I'm going to sidestep the answer, because in my mind and in my example, what made it a guerrilla tactic in appointing a biased arbitrator was that we were so biased, we were forced to challenge the arbitrator. So they forced us to start a procedure that would delay the arbitration by at least a month or more. Yes. And in a way, it's very clever, but it's also completely unethical. And in fact, I have another example where something quite similar happened. In that case, it was not their outside counsel they appointed. It was someone who was on their payroll, and the person was had an office within the company, an email within the company, was paid by the company. And as the arbitrator, would send out emails to the party using his @company.com email address, and then refused to stand down when challenged. So again, you got the most extreme bias, almost laughably so. And because of the rules that were applicable at the time, we had to go to the English court to get that arbitrator removed, which again added months.
That's really interesting. So the example we're giving was somebody who had a previous affiliation with a party and who was still using their email address from that party. Did I get it right?
Oh no, they had a current. They were getting paid by a party. They were working from the offices of the party, and to communicate with the parties within the arbitration, they used that party's email address.
Mm-hmm. You see how obvious that is, as catch, go after me. It's kind of yelling to Alexis, come on, challenge me.
Exactly.
Challenge me. And it's gonna it's additional costs, it's gonna delay the proceedings and so on and so forth. The example you gave me is more of repeat appointments. So factually it might seem unfair or unreasonable in the eyes of one party, but the IBA guidelines are putting them in the, you said, orange category, the repeat appointments, because they were more than 3 years ago. Is that right?
Mm-hmm.
Well, again, you know, it's a question that's very relative, right? Because it's the IBA guidelines are, which, you know, just to clarify, because I know there's a lot of people connected that are very experienced, but that they might be also students. The IBA guidelines, they give you the guidelines, first of all, so it's soft law. So it's not, it doesn't apply automatically. It applies only if the parties agree for them to be applicable. That's the first point. The second point is they have this traffic light system of what is acceptable in terms of, you know, representation, relationship between counsel and arbitrators. And in the green is, you know, green, red, and orange. It's just the governing of, you know, what is acceptable and not. And if something is not in the red, then the question is, you know, would that be a guerrilla tactic? My answer to that is no, of course not. It's not automatically a guerrilla tactic. You know, it's you have the right to do something. And then it's the appreciation of the arbitrator to consider based on the facts, specific facts. Now, I know you told us that it's 9 repeat appointments, but you know, what was the relationship? Is it just appointing the arbitrator? Is there another relationship ongoing? Was it also appointed by the other side? You know, maybe it was appointed equally by the other side, so it creates a certain balance. What has the arbitrator determined? Were these cases completely unrelated to the case at hand, or was it the same subject? I think it's a very relative question. So I don't think by just saying, oh, if you've appointed it already 9 times, it's a guerrilla tactic, unless it's clearly, you know, meant to be, like Alexis says, challenged. Now, of course, I'm speaking in my own capacity. I think I should have said that before.
Yes,
I'm
yes.
Not speaking in
Everybody's speaking in their own, yes.
Yeah,
but Saadia, I think
can have.
The issue, I guess, is if you appoint somebody whose income as now let me add a fact. So the arbitrator in question is not a partner at a big international law firm, and clearly the bulk of their revenue would have come from these appointments, at least for a few years. That would create a relationship that I think would be a bit too cozy between the parties. At the same time, it's very clever because based on the IBA guidelines, which while only soft law instruments are incredibly influential in challenge decisions, as we know, based on these guidelines, there is, I don't think a challenge would be extremely likely to succeed. So you basically appoint somebody who you know is going to be biased, who owes you and who owes you bad, but somebody who cannot easily be challenged by the other side. So, and in Alex's example, it was the opposite. It was really somebody who was so biased that they know you're going to have to challenge. But here the point is not to win the challenge and keep the arbitrator. The point is to delay the proceedings and make them costly and yeah.
Let me again, you know, just to explain that this argument might have 2 sides. I'm not saying I disagree with you, but the other side might say, okay, we've appointed him 9 times, but that arbitrator has, you know, 120 appointments within that period of time. So yeah, or his share of revenue represents like 10% of his overall revenue. So how is he financially dependent on our appointments to the extent that it will make him biased? Do you see the argument? So
yeah. It's fact specific. It's very fact specific.
It really fact specific. Yeah.
I mean, and to give credit, I think, to the IBA guidelines, they have, if I recall correctly, they have non-waivable, there's red list, which is waivable, the parties can give it up, but they have also the core obligations are non-waivable red list. Mm-hmm. And I recall that includes having a financial interest in the dispute or one of the parties. Mm-hmm. So I think if the arbitrator has a financial interest, and that would be the case here, that would mean they just can't stand. Now, of course, Saadia's very right, and you're very right, Remy. If it's just a very tenuous financial interest, then it's debatable. But if they are financially dependent in some way on the party, of course, they need to be set aside.
Mm-hmm. Very interesting. So I think these challenges to arbitrators are really a fertile ground for potential guerrilla tactics. So moving on, I guess, in the arbitration, the chronology of an arbitration, that there's the time of the hearing. Alexis, you already talked about tactics that aim at derailing the timetable of the arbitration. That works well if you're a respondent and it's in your interest to try to slow down the arbitral process as much as possible. Do you have any examples specifically about timetabling the hearing, maybe, and how this this can work as a guerrilla tactic?
I've got so many. I mean, it's almost, there's very few arbitrations where at some point one of the party is not trying to use a hearing time in a way that works for itself, not the other, particularly when there are different cultures. You know, if there's the Orthodox Christmas, if there's Ramadan, if there's the Catholic, the Christian, you know, 25 December, Christmas, people can work around holidays. They can use Sundays or Fridays and Saturdays. They can be emails sent late at night. It's almost in every single arbitration. It's quite rare that there's an arbitration when one party is not trying to use the holidays of one party, the availability of a witness to try and influence the hearing dates and times in a way, or even submissions the way that suits that party. One thing, are we going to, I imagine you're going to move to the hearing later. I don't want to go ahead. I suppose one thing we can speak about now that I found that happened several times was actually hiding documents that had been requested through disclosure among other documents. And there's various ways that can be done. And I've seen all of them done. One of them is, for example, in disclosure, you send one PDF with 1,000 pages, and somewhere in the middle, there's the important document. Or, and that's actually the very first arbitration I worked on as a student, was being paid by some of the counsels for the claimant to go, they hired, I think, 20 or 30 students to read about the 160 cubic meters of papers and see through to decide what was relevant, was not relevant, because they had to receive 160 cubic meters of documents in an attempt to hide the useful documents. And luckily, we managed to dig up a 2-page document that was in the middle of one of the boxes. So they had disclosed that document, but it had been hidden away. Yeah, that was clearly illicit. And then there's a lot more in respect of the hearing. Then the other thing actually that's also used as an example is witnesses that become available or unavailable based on what agenda suits the other side. So quite often key witnesses, if suddenly they are weakened, will be ill or on holiday or have left the company and be no longer available for the hearing or the process as soon as it suits the other side. That again, I've seen several times.
I remember a case about the scheduling and the hearings when I was working for an arbitral institution in a previous life. I remember a fairly big arbitration where one of the parties, presumably the respondent in the case, had challenged an arbitrator just the week of the hearing, so just the week before the hearing. And I suspect that the expectation was that the arbitral institution would take a long time to decide the challenge, and that the arbitral tribunal would decide not to hold a hearing while one of the 3 arbitrators was still under a challenge. And what the institution was able to do was to decide that challenge over a weekend. It was a bank holiday weekend, actually, and the institution decided and provided a reasoned decision within 3 or 4 days. But despite that, I think the arbitral tribunal decided to it was too late for the arbitral tribunal. They had cancelled their flights, and so the trick worked. But I think it's much more common than you would think to challenge arbitrators to disrupt the hearing. And again, the compounded effect, as Alexis or Saadia mentioned before, is that if you have very busy arbitrators, then rescheduling a hearing, of course, can be difficult, and you can end up with a hearing a year later. So it could actually work pretty well if you're trying to drag your feet.
Yeah, just to clarify on this point, Remy, as you mentioned, the reason why also this happens is just because you have to suspend proceedings if there's a challenge of the arbitrators and under most rules. And so again, the law is giving you the right to challenge. You have the right to challenge an arbitrator or the entire tribunal, for example, because that happens also. But if you do so, then the immediate result is the procedure is going to be suspended. Isn't that a great effect, a great result for your client that that wants to delay the proceedings for XYZ reason related to money? That's an automatic direct effect, I think, and that's why it happens more often than we say. And poor institution representatives, some of them are connected today. Like you say, the onus is on them to render, to push the arbitrators to render a decision very fast if it's an institutional arbitration. Yeah.
So I think I'm going to mention one guerrilla tactic that I've seen in a case in recent years. I think it's bordering on the acceptable. I was on the receiving end of it, and I was quite admirative because it was very clever, but bordering on the guerrilla tactic. And that was a commercial arbitration arising out of a IP licensing agreement. And the other side were claiming all of a sudden that they had so many documents that were commercially sensitive, and they didn't want our client on the other side to get their hands on them through the discovery process, because it would give them, it was trade secrets or things like that. And our client who was a competitor of the other side would then benefit from that and would be able to replicate or gain a market advantage. And so they asked for all documents to be labeled attorney's eyes only, meaning that only attorneys were able to look at the documents that were produced through document production. But this dispute was incredibly technical. And so it was important for the lawyers, for us to be able to talk to the technical people, the non-lawyers in our client's company, to really understand what was going on, to really understand if the other side had committed a breach, or had misappropriated our intellectual property. The technology was just too complicated for lawyers to understand the documents without getting feedback from the technical people on the documents. And so by getting the arbitral tribunal to decide that all documents would be attorney's eyes only, the other side did a really good job of making it difficult for us to make the most of document production. So they gave us the documents, just it was more difficult for us to really leverage what we found through document production. I thought it was really, really interesting.
And all right, so I had something quite similar happen in the data room, where people were allowed to see documents only in that data room, and then they had to leave their laptops, phones, etc. outside, and they were only allowed to have one pencil and some paper. So of course, looking at highly technical documents with just a pencil and a paper puts you at a disadvantage compared to being in your office with your laptop, with your Excel, with all the tools you need to analyze it.
It's turn the heating on as well, very high, so that you fall asleep watching this.
Offering really tasty, plentiful food.
You drink vodka at the same time, yeah. Saying it was water.
So I think, looking at the time that we have for this webinar now would be probably a good time to just talk briefly about one last topic before we really open it up to questions. And that topic is, how can we really respond to these guerrilla tactics? We've touched upon a few things, but so whose job is it in the first place to try to counter these guerrilla tactics? Is it the opposing counsel, or the arbitrators, or the courts at the enforcement stage, or all of the above? And what tips do you have, if any, to handle these tactics when you see them?
Maybe I can briefly start, because one of the guerrilla tactics that I haven't mentioned yet, and which happens all the time, and again, query as to whether it's a guerrilla tactic, but in my experience has always been, is parallel court proceedings when you have a valid arbitration clause, and the other side is going to contest and contest and contest and say, well, no, then the courts in my jurisdiction are competent, so I'm going to start litigation. And then you have litigation proceedings ongoing, and surprise, surprise, you have a decision from the courts that is actually an anti-arbitration injunction. What do you do if you have that? An anti-arbitration injunction, and you can scream all you want and say it was, completely biased process, and the courts are corrupt in that jurisdiction, and or that the other side is very cozy with the courts. You can say whatever you want. You've got this anti-arbitration injunction. You've got this decision against you in that jurisdiction, which also means in some jurisdictions, just remind you that you cannot travel there without getting arrested. Okay, if you've got a decision against you. That also happens against the arbitrators, by the way.
Yeah.
If you have some criminal proceedings for being, impartial or lack of independence against arbitrators, that can happen even before the awards have been issued, because there's sometimes procedural, orders that are rendered by tribunals. That had happened in one of my cases, which was not in the favor of the other side. They launched corruption allegation proceedings against the arbitrators in their home jurisdiction. The home jurisdiction was where the arbitration was supposed to happen. And so as a result, the arbitrators were like, we're not going there, because if we go there for the hearing, we're going to get arrested. And it wasn't clear in the contract if it was the location or the seat. There was, ambiguity towards that. And so that creates a reason also for the other side to say, well, if you move the arbitration to a separate location, then I'm going to challenge that award. And that's exactly what they did. So you see that happens. This is just to give you context on the type of stuff that happens, where I would say the arbitrators have, some work, they can play a role, and then sometimes they can't do anything, right? So in the instance where there's parallel litigation and there's an anti-arbitration injunction against you, there has been an example where the arbitration procedure just continued, and they just ignored completely the anti-arbitration injunction. They just kept going. And that was the decision of the arbitrators, to do so. In the case where the arbitrators have been sued in the court jurisdiction because there are corruption allegations or whatever is happening, what do you do? What are the arbitrators supposed to do? They can try to move along the procedure and issue an award, which had happened in the case what I'm mentioning, where I was involved, but then the award is challenged, based on due process violation. And then what do you do, So I'm giving you more questions than answers here. Maybe the institution, of course, if you have a institutional arbitration, then the institution has a set of rules, and the institution can of course intervene. And I'm sure we're going to discuss some of the specific guidance that some institutions are giving right now on the change of rules. But what happens if it's an ad hoc arbitration? Then those rules are not applicable. So what happens? Alexis maybe wants to
Oh, I was nodding because I had very similar things happen as well. And like you, in my arbitration, where the other side passed a law, actually, to make it illegal to aid the arbitration, the arbitrators said, fine, we just won't go to that country. And they pressed on. Of course, I avoided going on holiday in that country. And then that reminded me of another case where actually criminal proceedings were started against the councils. So there were two started against me, one in France, because I'm French, and well, they were not really started, but they tried to start them in France. They went nowhere in France, of course. And actually, neither did they go anywhere in the local country, because even though they thought they were cozy with the authorities, the judge had nothing to do with that. So it failed completely. But they did try. They did put forward two complaints, criminal complaints, one in the home country of each council and one in the local country. But they went absolutely nowhere. So now it's an interesting story to tell on Zoom. But I did have a criminal proceeding started against me. That went nowhere.
So what would be a sanction to that? How do you sanction that kind of behavior? I mean, one of the things I mentioned already is during, of course, when you issue cost awards, you can sanction the behavior, and I've seen that happen quite often. You
That's a good question.
The costs. But what happened to you? Like, how do you sanction that?
Here in that case, we actually ended up settling extremely favorably. Extremely favorably. We got hundreds of millions paid to us, not us, not the councils. I got nothing for that trouble, but the client was very happy with getting about 130 million euros, but and more valuable rights elsewhere. But this is actually where we're going back to what we're saying, which is immediate cost orders would be a solution, But my experience is that there's so much time that goes by between the guerrilla tactics and the actual award that by then what was done is basically forgotten and maybe mentioned, but you don't see it really taken into account into the costs. What tends to be more taken into account for the costs is the relative success of the parties. So if you win the arbitration, you're more likely to get your costs in if you lose. But to what extent is guerrilla tactics taken into account? I'm not entirely convinced. In my experience, I haven't seen it. I've seen it only very rarely actually taken into account. In my experience, the tribunal are more likely to focus solely on the outcome.
But Alexis, I think it's a very interesting point, but don't you agree that sometimes there's a disconnect between what the award says and the true and full motivations for the arbitral tribunal to find in favor of one party or another? And sometimes that's because there is an amount of deliberation between the arbitrators, and so not everything makes its way into the text of the arbitral award. And so I'm wondering whether in circumstances where the arbitral tribunal, or a majority at least, feel that there's been guerrilla tactics employed by one side, whether they might really be willing to take that into account in deciding cost without necessarily going as far.
Absolutely right.
Stating that
it might well be that my understanding is due because the tribunal did not say they were basing the decision based on the conduct of the parties. You may be entirely right. So for example, in the case where we had an 18-month delay of the hearing, we ended up getting we won and got all of our costs back.
So one of the recurring themes that we're seeing in the chat, in the questions, is sanctions. So specifically beyond, I guess, cost allocation, is there any other sanctions that arbitral tribunals can apply? We've talked very quickly about the approach taken by the LCIA arbitration rules since 2014. It's probably worth explaining very briefly what that approach is. I mean, I'm happy to do so unless you feel comfortable, but let's talk about sanctions in general. What can tribunals do? Are they really able to sanction counsel or a party beyond costs? Should they be able to do that? What's your general views on this?
Actually, there's a wonderful observation in the chat right now, which is, can a cost order really be a sufficient sanction? Because really all it can do is award the costs. So perhaps sometimes the costs incurred in dealing with whatever tactic are insufficient to be a sufficient sanction. So it's a very good point just made right now in the chat. And do they have the tools? I think they do, because actually every single rule I'm aware of gives the tribunal the power to manage the proceedings, almost without limit, beside the agreement of the parties. And of course, public order, etc., etc. Now, but do they do it? No, I don't think they do, not enough. What could they do? I mean, I think it's on counsel to step up straight away and say, look, this is going on, point it out to the tribunal, because the tribunal will actually not be aware that it's a guerrilla tactic, and B, call for action. And then this is where the tribunal needs to stand up and not do what a lot of tribunals, what occasionally there's an alternative to do, which is seek agreement or a middle ground between the parties, but say, no, this behavior is not acceptable. We will not let it happen, and then move on. Just, for example, if it's a delay tactic, not allow the arbitration to be delayed. If it's new evidence that's seeking to influence the proceedings in a way that's not acceptable, not accept the evidence. So
procedural decisions. So you're saying, arbitral tribunals should use the discretion that they have under any set of arbitration rules with respect to the conduct of the proceedings, procedure, to try to counteract these guerrilla tactics, and they may need to be prompted by the other side, but they have, in theory at least, the power to do something about it when it comes to procedure. Now, obviously, that's not going to cover all of the situations, right? Like challenges to arbitrators, repeated challenges before a hearing, etc. But so is it worth talking about sanctions, or is that completely illusory? I don't know if Saadia has a view on that.
I think, so first on your point on the powers of the tribunal, the tribunal have, broad powers. powers, generally speaking, okay, to make those decisions, like Alexis has said, like refusing evidence, moving on with the procedural calendar if the other side is being shaky about his availability, being strict about the deadlines. Then sometimes some parties of counsel are shocked, but maybe they should spend more time in court and see what happens when you miss a deadline or when you submit evidence not in the right format. Okay, maybe we should remind them what the rules are, because in arbitration we tend to be a bit more too flexible. So here I tend to agree with a lot of people in the chat that there is this due process paranoia over arbitrators' head, and they're like, well, if I don't hear them out, or I'm going to cut slice the slice the apple into couper la poire en deux, we say in French, but I don't know.
Split the baby.
Split them. Okay, thank you very much. Thank you to my French friends who are helping me with that with our English.
I think we're all French here.
We're all three of us. Yes, we are actually. So just to say that, I think it's you have a broad range of powers, but there are powers that are not in the arbitrator's hands, and I think you need to have counsel also sometimes accept that the other side's counsel's behavior is unacceptable and borderline, a violation of their ethical standards. And it is very rare that we as a community, because we're all friends and we all work together, and I understand completely that, but that we also say, hey, you know what you're doing is actually a violation of your ethical rules under this bar. And if you keep going, we might actually go to the bar, because this is not right. And I know these are exceptional times, and it doesn't, not if you're going to delay proceedings, of course, but there are other instances where I've seen, some lawyers act in a way that was clearly not right. And if you kind of mention it, I think counsel should be brave enough to face their colleagues and say that they're not acting appropriately. It can't be all arbitrators all the time.
But then that takes me to that point of due process paranoia. Again, it's a recurring theme in the questions that we have in the chat. And Saadia, you said in the courts, in court litigation, judges are very robust, and we should perhaps remind parties in arbitration of what happens in the courts when you don't respect the rules. But of course, a difference is that judges can be robust. They can have that sense of judicial entitlement because they are court judges, and they don't have to worry about whether or not their decision is going to be enforced by the courts of a foreign country. It's not a private tribunal trying to issue a decision that ultimately will have to be enforced by and given the green light by a domestic court. There is a risk of appeal, of course, but the situation is not quite the same. And so it brings us back to due process paranoia. So this notion that arbitrators may fear that their decisions, that their arbitral awards may be refused enforcement or may be set aside by the courts of the seat of the arbitration if they take decisions, including on procedure, that are overly robust. And so I think there is a degree of due process paranoia. We were all saying that. The question is, how do we address that? And that's why I was interested in what the LCIA did with their rules from 2014 onwards, where they decided to have an annex to the rules, which contains some very basic ethical guidelines, and there are provisions in the rules that require parties to ensure that their counsel will abide by the rules, and then it expressly tell the parties and the arbitrators that the arbitrators have the power to take whatever measures they deem appropriate in case there is a breach of the ethical guidelines, and that could, as a result, include, as a case may be, excluding counsel from the proceedings. And I remember when the LCIA adopted these rules, some people welcomed them, some others were incredibly critical, especially a part of the Swiss bar, and for different reasons. Some were technical, some others were really philosophical. It was about choice of counsel. Parties should always have the right to choose their counsel, etc., etc. But what I liked about this approach, at least in theory, is that by putting it in writing in the rules, that the arbitrators have got the power to issue sanction against not just the parties, but their counsel, you make it just that much easier for arbitrators to take these sanctions. You make it less likely that they will succumb to due process paranoia. So I'm wondering whether part of the solution is not in being a bit more explicit about the sanction powers of arbitrators, just to avoid that due process paranoia that seems to exist anyway. I don't know if you
do you want to go ahead, or I was going to go ahead.
No, go ahead. I was just going to say, I agree entirely with Remy has said. I mean, I will have to say it would be a very brave arbitrator that would remove counsel, because obviously the right to counsel is one of the most fundamental rights that someone has. And I could imagine how the ensuing award might be challenged. Nonetheless, and that's exactly your point, Remy, which I fully agree, having that power written into the rules will grant enormous confidence to the arbitrator. And I think it's a very good thing that the LCA rules has laid down those points. And then Saadia made such a great point, which I completely agree with, such a fantastic point. Most lawyers in international arbitration, if not all, are part of a bar with ethical standards that can be enforced. And if they are not complied with, then the other side, and also the arbitrators, should be willing and should have the power to go to the relevant bar and at least alert the bar to the violation that has occurred by the other counsel. Because I've had, in a past case, the other side's lawyer go to a local court in Switzerland and lie to the court. Absolutely lie to the court to get a decision that would help it in the arbitration for the duration of the proceedings. And of course, we could have appealed the decision, but by the time it would have taken to appeal the decision, it would be too late. So I was this close to going to their bar and raising the issue with them, because it was a clear breach of their ethical duties that lied to a court. But I didn't, and the reason I didn't was by then it was pointless. The harm had been done. That was it, and might as well move on. And the point crying was spilled milk and go ahead. But perhaps I should have, yeah.
So I think it's taking us.
No,
sorry, I don't want this to be the last thing, because it's a very cynical point. So please excuse me, everyone, if this is the last thing. I don't want you to finish on a negative point. But in addition to due process paranoia, there's another paranoia in arbitrators, and I'm sorry to mention that. But some arbitrators are also very worried about sanctioning counsel, because counsel is also, is the future appointments that they will be getting. Arbitration is a market, and arbitrators are appointed by the people they're seeing playing in the field. And this is the main difference with the litigation. And this is a problem that has been raised, I believe. And I think it's a real problem. And I think arbitrators have to be, more, confident, not only with the issue of, oh, my award is not going to be enforced or is going to be annulled and so forth, but also because they might not be appointed again, first of all, or they might not be appointed by these counsel in different proceedings.
But conversely, then, Saadia, if we don't want to end on a cynical note, conversely, if the international arbitration community is a market, I guess from a game theory point of view, whenever counsel intervenes as counsel or as arbitrator in an arbitration, it's not a one-shot game, right? It's a repeat game. So every time you intervene in an arbitration as counsel, you potentially do things that are going to be helpful or unhelpful to you going forward in your career, in your profession. And so you would imagine or hope that this market could be self-policing in a sense, or to a certain extent, that people who quickly develop a reputation for being keen to engage in guerrilla tactics would, as a result, not be appointed as arbitrators by their colleagues who are counsel. I don't know if it's wishful thinking, but I would like to finish maybe on a positive note like this one.
That's much better. Thank you.
Are you on mute, Remy? I think you're on mute. Remy, we can't hear you.
Yeah.
You're back.
All right. So I was saying that I think sadly this is taking us to close to the end of the time that we have allocated for this webinar. I'm delighted by the discussions we've had, Saadia and Alexis. Thank you so much for sharing your experience with us. I think it was great, certainly great for me. So I hope it was as well for our students, alums, and friends. I don't have anything to add apart from my thanks to you. In a traditional setting in London, you would be receiving a lot of applause by our students. Sadly, in this world that we live in, we have to do this online. So we'll have to say thank you otherwise. I think it's really covering everything here. I see that the school founder, Julian Liu, Professor Julian Liu QC is here. I don't want to put him on the spot. I don't know if he has any message to pass to everyone. If he wants to, then now is the time. Otherwise, I think it leaves us with goodbyes. Thank you so much, everyone.
Thank you, Remy. Thank you, Saadia. I learned so much from you both. Thank you so much. It's a really interesting discussion, and the contributions as well are fantastic. Thank you.
Thank you very much to everyone, and apologies to all those who raised amazing points. We just didn't have time to get into it. We'll just have to get together again. Thank you again, Remy.